If you thought the Elon Musk versus Sam Altman trial could not get any more dramatic, Day 4 just proved you wrong. And the person who ended up at the center of the storm was not even one of the main names on the lawsuit. It was a man most people outside of Silicon Valley have never heard of, a behind-the-scenes billionaire handler named Jared Birchall. And by the end of the day, Musk's own legal team was scrambling to undo what he had said on the stand. Let's back up and make sure everyone is on the same page, because this case has a lot of moving parts. Elon Musk co-founded OpenAI back in 2015 alongside Sam Altman and Greg Brockman. The original idea was that OpenAI would be a non-profit, open-source research lab focused purely on building safe artificial intelligence for the benefit of humanity. Musk donated roughly $38 million to get the whole thing off the ground. Then, as the years went on, OpenAI started shifting toward a more commercial structure, struck a massive partnership with Microsoft, and eventually restructured entirely into a for-profit public benefit corporation. Musk was not happy. He sued Altman, Brockman, and the company in 2024, arguing that they betrayed the original mission and used his donations for unauthorized commercial purposes. Now, this trial is happening in federal court in Oakland, California, in front of Judge Yvonne Gonzalez-Rogers, the same judge who handled the Epic versus Apple antitrust case back in 2021. The trial started on April 28, 2026, and from day one it was clear this was going to be anything but boring. Altman had teased the whole thing in February by posting online that he was, and I am paraphrasing, very excited to get Elon under oath, calling it Christmas in April. So yes, the tension was already at a full boil before anyone even walked through the courthouse doors. Musk spent the first few days on the stand himself. His lawyers tried to paint him as a principled founder who genuinely believed in OpenAI's mission and never would have donated his money if he thought it was going to fund a competitor to his own ventures. OpenAI's attorney, William Savit, had a rather different set of questions. He pushed Musk on whether he knew Microsoft was heavily involved as far back as 2020, pointing to a post Musk himself wrote on X saying OpenAI was essentially captured by Microsoft. If Musk knew that in 2020 but only filed his lawsuit years later, that raises serious questions about the statute of limitations. Savit also asked Musk whether a for-profit AI company poses a safety risk, to which Musk said yes, and then had to acknowledge that this included his own company, xAI. It was a small but telling moment. And speaking of xAI, Musk admitted during cross-examination that his AI startup had at least partly used OpenAI's models to train its own systems through a process called distillation. In other words, the man suing OpenAI for going commercial built his competing product partially using OpenAI's own technology. That is the kind of detail that tends to stick with a jury. If you're finding this story as fascinating as I am, do me a quick favor and hit the like button and subscribe to the channel. We cover AI, tech, and big business stories like this one every week, and you do not want to miss what comes next in this trial. Now, once Musk stepped down from the stand, his lawyers called their next witness, Jared Birchall. Most people have never heard this name, but inside Musk's world, Birchall is essentially the man behind the curtain. He manages Musk's family office, a company called Accusation LLC, and also holds executive titles at both xAI and Neuralink. He's the person who handles the financial plumbing of Musk's empire, and during the trial, he was the one who apparently handled the wire transfers that constituted Musk's donations to OpenAI. His testimony was supposed to strengthen Musk's case. Instead, things got complicated very quickly. Here's where the drama really picks up. While the jury was out of the room, something happened that Musk's own legal team did not want the jury to hear. The judge was weighing a motion from Musk's legal team to have part of Birchall's testimony stricken from the record, specifically the portion where Birchall discussed xAI's bid to acquire OpenAI. When a lawyer tries to walk back their own witness's testimony, that's usually not a good sign. The details of why this particular testimony was problematic were not spelled out fully in open court, but the fact that Musk's team was trying to erase it says quite a bit on its own. Then OpenAI's attorney stepped in and pressed Birchall on a key claim he had made. Birchall had testified that he believed Sam Altman had been negotiating on both sides of the table during OpenAI's restructuring, essentially implying that Altman was acting in bad faith for his own benefit. When pressed on where this belief came from, Birchall said it came from public news reports and from what lawyers had told him. He then confirmed that he had no direct inside information from bankers, OpenAI board members, or anyone actually inside the organization. That's a significant concession. It means the accusation was not based on hard evidence, but on second-hand accounts and media coverage. For a jury, that distinction matters a lot. Then came the questions about the money itself. OpenAI's attorney walked Birchall through the mechanics of how Musk's donations actually worked. Musk had channeled funds through what are called donor-advised funds, or DAFs, managed by Vanguard and Fidelity. These are financial vehicles where you put money in, get the tax benefit, and then recommend grants to charities. The key word there is recommend. Once money goes into a DAF, the donor doesn't have legal control over where it goes. When Birchall was asked whether Musk had any legal right to direct those funds after contributing them, he said he wasn't a lawyer and didn't know precisely. That answer played right into OpenAI's argument, which is that Musk's donations were not conditional, were not restricted, and were not legally binding commitments that required OpenAI to remain a non-profit forever. So by the end of day 4, you had Musk's own legal team trying to strike portions of their own witness's testimony, and that same witness confirming that his core accusation against Altman was based largely on news articles. Meanwhile, the financial structure of Musk's donations was being picked apart in a way that could undermine the entire basis of his lawsuit. The two main legal claims Musk is pursuing are breach of charitable trust and unjust enrichment. For the breach of charitable trust argument to work, his lawyers need to prove that his $38 million created a binding legal obligation on OpenAI to remain a non-profit forever. The DAF testimony threw cold water on that argument in a very public way. There are also some broader ironies worth noting here. Musk started xAI in 2023 as a for-profit competitor to OpenAI, then sued OpenAI the following year for becoming for-profit. His own xAI shed its public benefit corporation commitments in 2024 and then merged first with X and then with SpaceX. The company doing the suing has followed a strikingly similar trajectory to the company being sued. Whether the jury finds that hypocrisy legally relevant is another matter, but it's hard to ignore. The trial is still ongoing, and Greg Brockman, OpenAI's president, is expected to testify as proceedings continue. Judge Gonzalez-Rogers has made it clear she's running a tight ship and intends to keep things on schedule. Whatever happens next, this case is already reshaping how we think about the origins of the AI industry, what promises were made, and whether any of them were ever legally binding in the first place. This is genuinely one of the most consequential tech trials in years, not just because of the personalities involved, but because the outcome could affect how AI companies are structured, funded, and governed going forward. Stay with us as we continue to follow every development. And if you want to stay ahead of stories like this one, make sure you're subscribed because we're not done covering this trial by a long shot.